Good morning. The Hearing Board of the South Coast Air Quality Management District is in session. Today is Thursday, March 8th, 2018. The time is 9:00 a.m., and we are meeting in the Hearing Board room in Diamond Bar. We have two matters. One is under other business. We have one hearing for today, and that is the SCAQMD versus Nima E. Khalif, aka Nick Khalif, doing business as Nick Auto Body and Paint, case number 6096-1, which is an order for abatement. I'm going to call the case, but it appears we may not have a respondent this morning. So who is representing the executive officer in this case today?
Good morning, Brian Tomasovic for the executive officer.
Good morning, Mr. Tomasovic. And I would like to give the respondent some time unless you have some information, perhaps if you've spoken with the respondent or if you know that he will not be present.
It is my understanding that he will not be coming today.
And that is based on conversations with the respondent?
I spoke with him as recently as yesterday, and he indicated he would not be coming.
Okay. So with that, board members, let us proceed and not give any more time for the respondent to come, but that would also mean that we will have to begin by hearing evidence on, which we do have, service of the respondent to make sure that we can comply with Rule 7B2, which is if the responding party fails to attend the hearing and the petitioning party has provided the hearing board with proof of service, which they have, on the respondent of the petition, the hearing board may rule on the petition in the respondent's absence. So with that, Mr. Tomasovic, if you don't mind, we can begin with your opening. You can do your opening for the case, as well as, if you don't mind, just mentioning to us where we will find, for the hearing board members, a copy of the proof of service. Oh, sorry. Before you begin, the Senator has a comment.
Sorry if I call you Brian, because I can't pronounce your last name. I apologize. Was he notified about this hearing today?
I can address that. He was given personal service. It doesn't get better than that. We filed the proof of service with the clerk. The other line of evidence that I could mention is we filed a document on the 18th of March titled Notice of Intent to Introduce Declarations as Evidence. One of those declarations was executed by Thomas C. Fraser. He's the investigator that personally served Mr. Khalif, the respondent, at his business, and he describes that he did so with verification of his ID, handing him a copy of the petition.
18th of March?
My filing was the 18th of March. Service was accomplished on...
In January 24th, I believe.
January 24th, correct.
Before we get into questioning, because Mr. Tomasovic is not actually a witness, let's allow him to give his opening. And at this time, what I'd like to do is, I'd like to introduce, well, not introduce, but I would like to mark each of the exhibits that are attached to the Notice of Intent to Introduce Declarations as Evidence. And I'd like to note for the record that under exhibit number 1, which is attached there too, we have been provided with the letter that was sent according to the, let me just start with our Rule 8 so that we can introduce this as evidence. Our Rule 8C, which is evidence upon affidavits, same as declarations. The requirement is at least 10 days prior to the hearing. Any parties that propose to introduce an affidavit into evidence shall mail or deliver a copy of such affidavit to all the parties together with notice as provided below. And in subsection 2 of that rule, is the paragraph that must be sent, which speaks of the ability to cross-examine, and that will be waived, and the declarations will be admitted as evidence if the parties do not respond within a certain period of time. I'm going to mark Exhibit 1 through, I believe there are 6 of them, as they are marked in that notice of intent to introduce declarations as evident. And I will note for the record that all of the requirements of Rule 8C have been complied with, as is evidenced by the notice itself and the accompanying letter dated February 23rd, which is Exhibit 1. So I'm going to mark all of those separately as Exhibits 1 through 6, and I'm going to, because they have complied with Rule 8C, our Rule 8C, I'm going to mark them as evidence so that we can refer to them in our deliberations. And with that, Mr. Tomasovic, I'm going to allow you to make... Oh, sorry.
Could you please, for the record, state
What each one is?
please?
Yes.
Thank you.
Let me do that. Okay, try to mark them. Okay, so Exhibit 1 will be marked as a letter on South Coast Air Quality Management District letterhead. It is dated February 23rd, and it's to Mr. Nima Clafe and Nick Auto Body and Paint. That will be Exhibit 1. Exhibit number 2 is going to be the declaration of Eduardo Esparza. Exhibit 3 will be the declaration of Thomas C. Frazier. Exhibit 4 will be the declaration of Gian Cavoto. Sorry, we have technical difficulties sometimes with the phone calling in, and we don't know from where, so we'll just wait for that to finish so it's clear on the record. Okay. And thank you, Madam Clerk, for having me go through this, because I see that there are only 5. Thank you. Declaration of Donna Peterson will be marked as Exhibit 5. And again, all of those will be placed in evidence because all of the requirements of Rule 8C have been complied with. Now, Mr. Tomasovic, if you can give us your opening, I appreciate it.
Good morning. The hearing board has just admitted some evidence to show that the respondent is in violation of District Rule 203A. Specifically, the respondent runs a paint and auto body shop in Northridge. At this facility, he owns and operates a paint sprayer booth to apply automotive paints and coatings for his customers. The paint sprayer booth once held a valid permit, but it is now expired and invalid, so he is operating without a permit. Respondent previously had a payment plan with the district, but he defaulted on that, and as stated, he has no permit. Respondent has stated he does not have the money to submit an application and pay the outstanding fees, and he may be correct in that, but it does not excuse the violation or diminish the need for an order for abatement. Evidence will also show that the respondent has been in violation of record-keeping requirements of District Rule 109. District Rule 109 is needed to, is used to determine emissions and also to determine rule compliance. Complying with Rule 109 does not require the submission of any fees, only the keeping of the records, yet as detailed in the declarations that were introduced in evidence in each of 4 recent visits to the facility, district personnel have not been able to verify the facility's compliance with Rule 109. We, in fact, have a declaration from investigator Thomas Frazier in this case, and he had served that petition for this matter on January 24th of this year, and he asked whether paint usage records were being kept. As you'll see in his declaration, he says that the respondent replied, "Not yet." In these circumstances, it is appropriate for the district to request an order for abatement and for the hearing board, in consideration of the evidence that's received, to support the findings and decision to issue the order for abatement. And that concludes my opening.
Thank you, Mr. Tomasovic. And how do you, well, I see in the declaration of Mr. Thomas Frazier, and in particular, I'll draw the hearing board's attention to the first page. So this is Exhibit 3. It's attached to the Notice of Intent to Introduce Declarations as Evidence. It is the declaration of Thomas C. Frazier. And in paragraph number 4 on the first page, this is evidence of, I served Mr. Nima E. Clafe the petition for order for abatement in this case at approximately 11 a.m. on January 24th, and it goes on to say how he accepted his driver's license, etc. Mr. Tomasovic, can you tell us where, I'm still searching, did you submit the proof of service? I see the proof of service for the intent to introduce declarations as evidence, but of the petition itself?
I'll have to see whether that's in my folder as well. I may have been mistaken in stating that that had been filed, so
Would you like to go off the record?
please.
Yes, we're off the record. We're back on the record, and while we were off the record, Madam Clerk, because in the copy that I was looking at, it didn't have the proof of service at the end. But in the copy that the clerk has, and hopefully everyone else on the board has, and please let me know if you do not, and we can have copies made. But at the very back of the petition for order for abatement in this matter, the very last 2 pages there's a cover page, caption page, proof of personal service, and there is a proof of service dated, the date of proof of service is January 24th, 2018. By personal service is checked off, and it was signed Thomas C. Frazier. Does everybody have a copy of that at the back of their petition? And if not, let us know if you need a copy made, but it is in the record.
Thank you. I don't have the copy myself, but I do understand there was an exchange where that was requested and submitted.
We appreciate that. Thank you. I think at this point, I think it makes sense for us to stop and go to the hearing board and have some deliberation, or unless there's any questions that any hearing board members have with regard to the service of, do you have any questions, Senator, with regard to the service? Because we now have, again, according to our rules, we can proceed in the absence of the respondent so long as the petitioner, so long as the district has provided us with a proof of service. The district has done more than that. The district has provided us with a proof of service, and in addition, a declaration of Thomas Frazier, wherein he describes how he served the respondent's response, and his review of the California-issued driver's license of the respondent. Any questions? I don't know if we even have do we have Mr. Frazier available? Should we have questions?
He's present.
Okay. Would anybody have questions for Mr. Frazier?
Not on that issue.
Not on that issue, okay. So with that seen, I would like to begin with just a short deliberation as to whether or not we want to proceed, and I believe that the plain language of our rule allows us to proceed in the absence of respondent. And given the weight of the evidence, given the history of this respondent, given what I see in the declarations as clear knowledge of the proceedings in this matter, and if there's any question, I have an exhibit that I can introduce because the respondent requested an extension of the date of the hearing, which was denied because the understanding of the chair was that the response was because of hardship, and the response of the chair was, we will not delay the hearing for that reason, but rather you can come and make any argument you wish with regard to hardship. And we would take it into consideration at that time. And so showing a clear understanding of this date of this hearing. Senator, did you have anything you want to add?
And the notice of intent to introduce a declaration was also served. And I think the service was by mail, and it was deposited in the mailbox on the 6th of March. If that being the case, could the respondent receive it in a timely fashion to respond yes or no?
May I respond?
Yes, Mr. Tomasovic, please.
The notice of intent was filed and mailed on the day it was filed, but the letter that provided the actual notice of evidence upon affidavits was admitted as Exhibit 1, and it was sent on February 23rd, within the time allotments provided by the rule for submission of declarations and affidavits.
And just a reminder of the rule is 10 days in advance, and it was sent on February 23rd, which is more than 10 days.
Notice for the petition, but not for entry.
No, sorry, we're dealing with two different rules. Okay, the rule I'm now referring to is Rule 8C. And Rule 8C is with regard to a notice to proceed on declaration or affidavit. Hold on, I don't know why I keep losing that rule. Okay, and that rule with regard to affidavits proceeding on declaration, that's separate from the question of whether or not the respondent was served and he has not appeared today. This is a question as to whether the affidavits are proper and can be admitted as evidence. And that rule, 8C1, says at least 10 days prior to hearing or continued hearing, any parties that propose to introduce an affidavit, declaration, into evidence shall mail or deliver a copy of said affidavit to the other parties with a notice as provided below. And that is the notice. If you look at Exhibit 1, which is dated February 23rd, 2018, which is more than 10 days before today's date, there is in a box something entitled Notice at the bottom of the page. That is the required notice.
But
Right.
how were they notified? In their hand or with the mail? It was mail on the 6th.
I know what he's referring to. So at the very back of the Notice of Intent to Introduce Declarations as Evidence, there is also a proof of service. I'm not sure. I don't know if Mr. Tomasovic can explain why there's a different date, but that is the date that is, I think, confusing to the senator and perhaps other board members as to why that's the 6th, but the letter is dated February 23rd.
Apologies for the confusion. When we pre-filed to give notice of our intent to admit the declarations, we sent a courtesy copy to Mr. Cleve. And yes, it may be the case that that's going to arrive in the mail a day or two, but it doesn't change the fact that even if we hadn't done that pre-filing, we would have been entitled to show up with a copy of the letter and a copy of each of the declarations and moved for them to be admitted. So there's no prejudice to Mr. Khalif in the fact that we sent him a copy of the filing, which is our action in filing that did not admit anything into evidence. It was just a notice document.
And Mr. Tomasovic, may I ask you, you're the one who signed the letter that is Exhibit 1, dated February 23rd. Can you testify as to, oh, sorry, you're not, you can't testify. Can you tell us whether or not you actually mailed it on that day, or it was mailed on that day?
There is a proof of service, at least in my records, that shows Rachel Mendoza, of personnel of the AQMD, had dropped this in the mail on February 23rd.
We have the one from Rachel Mendoza saying March 6th.
And I have that as well.
Okay, so you have a different one.
Yes.
So, okay, we do? Yeah. Oh, oh, I'm sorry, I'm missing the first one before. Okay, so there is one. So Senator, you saw that then, the one before it. Okay, so there is one on February 23rd. Okay, thank you. Any other questions about whether or not we can proceed in the absence of the respondent? Or any other? Do you want to ask that question? Ms. Byrd has a question. Mr.
I'm sorry, I
Thompson.
may have misunderstood your explanation, but why were there two proofs of service here? If it was mailed on the 23rd, why was there the March 6th mailing? Was that just?
The March 6 proof of service relates to the pre-filing. So that's the document we filed with the clerk on the 6th of March with the caption titled Notice of Intent to Introduce Declarations as Evidence. That includes, I mean, that's a new filing and it has my signature on it. We sent him that, and that also included attachments that he already had before.
So you sent the same thing twice, basically?
With the exception of my
With the
filing
exception of
cover
this,
sheet.
this cover sheet, that's the only thing?
That's
Okay, so
correct.
all the exhibits
Have been
were
sent
already,
twice.
okay. I just wanted to make sure.
And may I ask, and the reason for that it was sent twice, is because in order to file the notice of intent to introduce declaration as evidence, you had to prove that you served it 10 days before. Is that correct? So you served it 10 days before. You had the proof of doing that.
And there was no response, is that why?
There is need for a record statement, I believe on my part, that after the 7 days had passed, I received no demand to cross-examine the declarants, and I can state that I did not receive any such demand.
Okay, thank you.
Okay, board members, then I'm gonna move, since Rule 7B2 is not mandatory that we proceed in the absence of the respondent, but I'm going to move that we do proceed in absence of the respondent, given the proofs of service that we have seen, given the declaration of Thomas C. Frazier, which explains service and the receipt and review of the respondent's California-issued driver's license, and the weight of the evidence, which shows that the respondent was well aware that today was the date of the hearing. Is there a second for that motion?
I second it.
Okay. Any discussion on that before we move for voting? Mr. Camarena? No, no discussion.
For the vote?
I will call for the vote. Mr. Camarena, how do you
Vote
vote?
yes.
Okay. Dr. Lerner, how do you vote?
Yes.
Senator, how do you vote? Okay, so we're going to proceed. Mr. Tomasovic, how do you want to do this? Do you wish to present any witnesses, or do you wish to just present and based on your declarations, and if we have any questions, I see that we appreciate it, that you've brought, I think, probably all your witnesses. Would you like to just proceed that way?
Well, there's two documentary exhibits I'd like to move to admit.
Sure.
And they are authenticated by the declaration of Inspector Eduardo Esparza. So attached to the petition for order for abatement as filed on January 19th, we have a copy of the notice of violation that's referenced in the allegations of the petition. And we also have a copy of the expired permit for the spray booth. So as the next exhibits in sequence.
Okay, thank you. Then I will, we will mark and put in evidence, notice of violation. Where's the number on that? Well, it's dated the 3rd of March, 2017, and that will be Exhibit 6. And then what follows that is permit to operate. It says on top NOV P60691, attachment number 1, and we're going to separately mark that as exhibit number 7. And with that, Mr. Tomasovic, do you wish to, at least for now, rest on the declarations?
So we have no further evidence or update regarding respondents' compliance status to alleviate the need for an order for abatement. I would rest, but there are several of the declarants for the declarations that were admitted into evidence that are here, and if it is the pleasure of any board member, we could have them sworn in and speak to any questions you may have.
And that's what we'll do. So, board members, we have received all, I think there are 4 of these declarations. Does anyone have any further questions for any of the witnesses before we go into deliberation and make a decision in this matter? I had one question, and I don't know, I think it would be more for you, Mr. Tomasovic. I had an issue with the form of the order with regard to number 2. So if we're looking, for everyone's reference, we are looking then at the proposed findings and decision for an order for abatement. And we're looking at the very last page for under the order, the first paragraph. And the question I had was, it's clear that number 1 is to immediately cease and desist from operating the paint spray booth until such time as respondent submits the application. Number 2 is less clear what the until is. So 2 is immediately cease and desist from the use of coatings and solvents at the facility without maintaining the usage records required by District Rule 109. And perhaps, Mr. Tomasovic, it would be helpful if there were a particular witness we could bring on to explain what the trigger should be in terms of when this order for abatement would stop abating usage of the paint spray booth under number 2. Would that, unless you can answer that question, but I think I'd prefer a witness if you have one.
Sure. District Rule 109, the rule section that we've cited requires the maintenance of daily records for paint usage, but we can call Inspector Esparza to speak more
Okay.
to it.
Then I'm gonna ask everyone who has come who could potentially be a witness today to please rise to be sworn in. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Okay, thank you. Okay, Mr. Tomasovic, if you can introduce, did you say Mr. Esparza is going to? Okay, and perhaps if you can answer that question.
Mr. Esparza, could you please state and spell your name for the record?
Eduardo Esparza, Esparza. First name Eduardo.
Mr. Esparza, are you the signatory of the declaration that was admitted as Exhibit 2 in this case?
Yes.
To the question that was just asked, I am handing you a copy of what was pre-filed as proposed findings and decision for an order for abatement in this case. And the chair was speaking to what's on the last page, page 4, the parentheses around the number 2. There may be ways to improve the way this is phrased, but can you explain what are the obligations of the respondent in record keeping that he should cease and desist from under Rule 109?
Can you elaborate on that question?
Okay, well, what does Rule 109 require of the respondent?
Rule 109 requires the respondent to maintain records in terms of how much coatings he uses.
And solvents as well, if he does use solvents?
Yes, anything containing VOC.
And I'm handing him a copy of Rule 109, which has not been admitted, but is a public.
It doesn't need to be, we can recognize that.
As in terms of daily or monthly record-keeping activities, can you speak to what Rule 109 specifically requires?
Sure. Rule 109 C1 requires any owner or operator of a stationary source using adhesive, coating, solvents, and/or graphic art materials, and subject to this rule, shall maintain daily records of operation for the most recent 2-year period.
And suppose an order for abatement is issued, an order for abatement is issued on Rule 109 compliance, what should he be doing as a daily matter?
He should be maintaining some sort of log indicating the usage for any coatings or solvents used.
If he has a day where he's not using any paints or solvents at all, what would you expect to see?
He could put a 0 or a not applicable or something to indicate that no coatings or solvents were used for that day.
And does Rule 109 specify the when coatings or solvents or other VOC products like adhesives are being used by a facility, does Rule 109 specify detailed information that should be kept?
Yes.
In your declaration, you state that you've recently made 3 visits to the facility, is that correct?
Yes.
And in each of those visits, did you ask for records?
Yes.
And what did you find in response to your request?
The owner indicated that he was not keeping any.
I have a follow-up question. Mr. Esparza, you testified that the requirement in 109 is to keep these daily records for the most recent 2-year period. Is that correct?
Yes.
Okay. So if you were to, I just want to understand how this is going to work. So an order for abatement is put into effect today. Just say that happens, and then a week from today, you or another inspector inspects respondent's facility and finds that for the last week, in fact, daily records have been kept. Would, in accordance with District Rule 109, as they're supposed to be kept and as is specified in the rule, would you be able to find that they were maintaining usage records required by District Rule 109?
Yes.
Okay. Okay, so I wanted to have that understanding. So if we said immediately cease and desist from the use of coatings and solvents at the facility without maintaining the usage records required by District Rule 109, whenever you inspect, so long as you see that there are daily records for some period of time, you would be able to find that they are maintaining those usage records?
That is correct.
Okay. And Mr. Tomasovic, your understanding of this is it's really on the respondent as soon as, well, if respondent has also complied with number 1 and has in fact submitted an application and fees for a permit, and then on top of that has been in compliance with Rule 109 for quite some time, he may resume under the order for abatement. Is that your understanding of how this would work?
Yes, so Rule 109 is not limited to capturing painting activities that would happen with the spray booth. To the extent he would use coatings or solvents outside of the use of the spray booth, he would also be obliged to keep records. And it's possible, and you could say it's easy for him to begin complying with an order for abatement immediately, so long as he begins to keep daily records.
Thank you. Board members, any other questions for Mr. Esparza on that issue, or anything regarding his inspections and the NOVs? And you, if you haven't yet, you can find his declaration as Exhibit 2. Dr. Lerner.
Just to clarify, Rule 109 applies to the property, not the, including the spray booth. So if he wanted to spray outside the spray booth, he would have to keep a record of what he used. Is that correct?
Yes.
Thank you.
Any other questions for this witness? Any other questions for any other witnesses, board members, or are we ready to proceed to deliberation? I am seeing none. No questions. Okay, Mr. Tomasovic, I'm going to allow you to do your closing, and then, oh, is there any member of the public who wishes to be heard? And I'm seeing nobody except for the witnesses. Mr. Tomasovic, your closing.
To close, the district urges that you issue an order for abatement that orders the respondent to cease and desist from his violations. The proposed findings and decision document has been filed with the clerk, and it does propose a duration of the order of 18 months, which should be adequate for the district's purposes in seeking to ensure the order is followed once it is issued and effective.
Thank you very much, and thank you for making this presentation so comprehensive so that we could have this hearing quickly. It's a shame that respondent did not show, because I specifically, as the chair, when requested by the respondent for an extension of today's hearing, denied the extension of the hearing, knowing that this case has been going on for a long time, but specifically said that if there's hardship, he would have an opportunity to argue that today. He chose not to show, and so as a result, we have not heard his arguments with regard to hardship. And that's unfortunate. We have no evidence as to that. But what we do have evidence as to, fellow board members, is noncompliance with permitting rule of the district since March of last year. So for an entire year, not only has this facility been, this spray booth, excuse me, been unpermitted, but I think it's been inactive, and I can't recall, I don't have it here, but I don't think it's capable of being reinstated. It's not reinstatable. And that's been since March of last year. We also, and that's despite the evidence that we've received with regard to the payment plans from Ms. Peterson. That's exhibit number 5, Ms. Donna Peterson, who testifies through declaration that payment plans were offered to the respondent. And so respondents, any hardship that the respondent may or may not have has been taken into account by the district, and payment plans have been offered, and the respondent still has not come into compliance with regard to permitting. With regard to keeping records, I think that's even more of a problematic violation. It doesn't cost money to keep the log. However, this respondent has been inspected on several occasions, and every single time a new inspector comes or an investigator comes to serve, we can tell through the declarations that the respondent still willfully fails to maintain the required records. And that's a problem, because there is no record or knowledge of how many coatings or how often this spray booth is being used. I see from the declarations of Mr. Esparza that originally the respondent was maintaining that the paint spray booth wasn't being used since the last NOV, but by the time I think the second inspector had come to the facility close to the time of the hearing, the respondent was admitting that he was using it up to 3 to 4 times a week. So it's very unclear how often this spray booth has been used. There's certainly been evidence upon inspection that it has been used. Either it was in operation at least one time, and there were coatings coating the entire spray booth, showing that, that there was use at least one other time. And so with all of that, I know we tend to like to give some time to respondents to come into compliance, but I think enough time has come. Respondent refused to show today or did not show today. And so as a result, I believe that we have enough evidence to adopt this order for abatement today and to stop the use of this paint spray booth until it actually is permitted and records are kept. Dr. Lerner, you want to add to the discussion?
Is it limited to the booth, or is it limited to or does it include the entire property?
It is the paint spray booth. So if you look on the proposed findings and decision for the order for abatement, if you read the first paragraph, it says, immediately cease and desist from operating the paint spray booth. It's two different things. Under one, it's the paint spray booth until submission of an application with the required fees. But if you'll recall, Mr. Esparza and Mr. Tomasovic mentioned that there might be coatings outside of the spray booth for which the respondent is not keeping record. So number two is immediately cease and desist from the use of coatings and solvents at the facility without maintaining the usage record. So as soon as respondent starts to keep a daily log as is required by District Rule 109, then the facility may use coatings outside of the spray booth, regardless of whether it's been permitted. Any other discussion, board members? Senator?
Ms. Donna Peterson's declaration. I'm looking at the amount of money that was requested of him. And the $331.81 was the last payment received. The only question that's raised as a result of that statement was that how many such payments like that was he required to pay in order to be
If I could, if you look at further down in that paragraph, the very last two sentences, or the second to last sentence, the most recently issued payment plan required 6 payments of $248.89 each, but the SCAQMD did not receive these payments.
I see that.
Oh, okay.
And my question would be, which does it relate to? Past due at the rate of 331.81, or going forward, the reduced payment plan, is that for each month, will it therefore become 248.89?
I do not know the answer to that. I only can tell you, and unfortunately the witnesses have now left, but I can only tell you that as I read it, it states that the most recently issued payment plan is 6 payments of $248.89 each, and that, as I read it, that's the total.
I was just wondering if that's retroactive.
Meaning?
Is it retroactive for violations that previously occurred, or use going forward?
All I can say is I do not believe that the district is going to charge any fees above what is required to reinstate that permit. I don't know the answer, though. Mr. Camarena might have an answer.
Excuse me, as I read it, you mentioned violations. This has nothing to do with penalties and violations. This has only to do with the amount of money that is necessary so he can apply for a new permit. Because the existing permit has expired. And so that's all that is needed at this point.
Permit to operate.
Right.
Is therefore going forward to be $248.89 each for 6 months.
Well, that was the payment plan. I don't know if the...
They put them on a payment plan for permit to operate.
Yeah.
And that's what they're going to cost. That's what it sounds like to me.
Okay, that was the payment plan, I think, for the past. I don't know if that's what he needs to pay all at once to get his permit, to get his new permit.
Anyway, she's
Either,
fine.
either way,
Ms. Peterson is gone, but his permit to operate henceforth, due to the problems which previously existed, would therefore be $248.89. Pay each 6, they made it convenient for him. That's what I think, for 6 payments. Thank you.
I agree, and I think that really, that's very good evidence of the fact that this order should issue, because I think that it looks like the district has gone out of their way to really try to make it easier for the respondent. Yes.
Just point of clarification. Thank you, Mr. Camarena, for defining what these payments are. Were these monthly payments?
Dr. Lerner, we are no longer, and in fact, we do not have that witness in the room, but we can discuss it amongst ourselves. What's the question? Because maybe we can answer it by looking at the
Well,
declaration.
I never saw is it monthly payments? Are these every other week? Are they weekly payments?
I believe it. I'm trying to find it. It looks like it was monthly.
It's not in, I don't think it's in here. But I could be
Says,
wrong.
why am I not? Oh, it doesn't say that.
6 payments,
It doesn't say that.
whenever.
Ms. Byrd?
I just want to say that I think in the past, we've heard cases where the fee review committee has made, tried to make it more, or tried to make it easier for petitioners, for respondents that have come before us to pay their back permit fees by breaking it up. And it's, my understanding is the review committee is a review process. They tell them they can't pay it, and they give them then an arrangement to pay it. And this guy was given an arrangement that he knew about, and he didn't choose, or he didn't choose to, or he maybe wasn't able to pay. We don't know that, since he hasn't come to tell us. So, but I do believe that, I think that in this case, the district went above and beyond because they made sure to do some things, personal service. I think maybe the last time Mr. Tomasovic was here, it was not, and there was a question. So the petition itself was delivered personally, NOVs were given personally.
I'm so sorry. May I interrupt you for a moment? Because we're going to lose Mr. Camarena. He has a personal
Oh, I'm
issue.
sorry.
He
I do
has
need to leave at 9:45, and
I need to pass that time.
Anything that you
For a
need to
very
say.
important personal matter.
Okay.
Sorry about that. Go ahead, Ms. Byrd. I did not mean to interrupt you.
No problem. So I do believe that in this case, actually I was hoping that we would get a call this morning and saying that the respondent had decided that they could come up with the money and pay it, because I hate when we reach points where we have to issue orders like this on respondents. But it is the way the rules read. This is the way it operates. This is a requirement of the district if you want to be in business and do these things, and that our hands are really tied when we have no one to explain to us why we should do anything differently. And for that, I'm really sorry that he did not come, but I do believe that we have everything here to issue this order for abatement.
I agree with that, but I also just want to add again, just for an exclamation point of emphasis, that there are 2 rules here that are being violated, and one is very willfully being violated because there is no fee involved with record keeping, and yet since the facility has been inspected, starting at least in August of last year, there's no record keeping. And it continues to this date. Anything else before I offer a motion? Because I'm ready to do that. Okay. Then in the matter of South Coast Air Quality Management District versus Nima E. Clafe, AKA Nick Clafe, an individual and doing business as Nick Auto Body and Paint, well, first of all, before I do that, I also want to just point out for the record that we also do have a declaration of Gian Cavoto, which explains the hardship in figuring out who the respondent and who the actual facility is and who the owner is of this facility. But I want to point out that there is a copy of Form 400A that is, it is a district document in their system of records, and Mr. Clafe has identified and signed forms on behalf of himself or on behalf of Nick Auto Body and Paint at the address of the respondent and has identified himself as owner. And so back into the motion. This is case number 6096-1. I move that in this matter, that we adopt the proposed findings and decision for an order for abatement, and we issue it today. And that we delete the word proposed from the caption and from the footer. In addition, on the first page, on line 25, that we add, well, sorry, starting on 24, there's an option of did or did not appear. Unfortunately, the respondent did not appear. And line 25, delete the words if applicable, because in fact, the line, the hearing board having evidence of proof of service on the respondent of the petition ruled on the petition in respondent's absence in accordance with hearing board rule 7B. We all found as a board that applied, and so we're going to add that in. And there are no other changes. Except to note for the record that Mr. Camarena had to leave before the vote. And that we adopt this for good cause as we have discussed through discussion. Is there a second? Dr. Lerner.
Second.
Okay. Any discussion on the motion? Senator? I don't think your microphone's up.
It's clear based on evidence that the respondent claimed hardship and did not have the funds to pay the district for the right to continue to operate. But there are two other things. One, he didn't comply with maintaining the records, which is required, I think 109, I think is what you say. And so therefore he's out of compliance. Number one. Number two, the district went beyond what's required of the district to provide an opportunity for the individual, the respondent, to comply by setting up a fee plan. The fee plan was for his convenience of $248.89 each for 6 payments. They reduced it. They were not demanding the full amount up front, which would have been certainly over $1,000, which he claimed he would not have had. And even with that being the case, he didn't make any payments, didn't respond to participate in the fee plan. And for that reason, I think that I'm going to have to vote aye on this motion.
Well, then, and if there's no further discussion, then I will call for the vote. And so Senator votes yes. Ms. Byrd, how do you vote?
Yes.
Dr. Lerner votes yes.
Yes, thank
Okay,
you.
and I vote yes. So the motion passes 4-0, and just for the record, I think we mentioned this, but Mr. Camarena had to leave just before the vote, and so that is why there is a 4-0 vote. Thank you, Mr. Tomasovic,
Thank you.
and thank you, Mr. Esparza. There is one other item on for the agenda for today, and it's just another business item, and that is the authorization request for payment of registration costs for board member Roger Lerner to participate in Fundamentals of Evidence course through the NJC. And if I could, Dr. Lerner, I'm just gonna start by just phrasing it We all will recall that Ms. Byrd had requested this last week during our general meeting, and Ms. Byrd's request was granted, and that there was significant discussion at that time about this evidence, fundamentals of evidence course, and that it is aimed at non-lawyers, and that it has real merit for the members of this board to attend, and that is why we unanimously granted it, that request. And during that discussion, Dr. Lerner expressed interest in this course as well. And so at this point, I'm going to allow Dr. Lerner to explain where he is in this process, but the request is slightly different. Whereas Ms. Byrd was able to put it on the agenda before she had to register, she was able to make the request and have the district pay her fees for attendance in advance through the money that's set aside for board members for training purposes. But Dr. Lerner, it's a little bit too late for that, and so the request is actually, if he can get into the class, to reimburse Dr. Lerner.
The same day that we had the meeting last week, I called them. I was told that it was filled and that there was one person in line as a backup, and I would be number 2. I called them yesterday to see if the status had changed, and had a very good conversation with somebody at the college who's in charge of this program, and she said that oftentimes somebody will start or not show up, start and drop out, or start or register but not show up. So there may be an opportunity for me to get started. I may miss a day or so, she said, but that's the burden you pay if you want to do it. And I don't want to wait another year, because we have a lot more work to do here, and I need the experience. So I'm hoping that I will be accepted, and if so, I will notify the clerk of the board, and I will pay for it and then get reimbursed. That would be my plan.
Thank you, Senator.
You would pay for it? I mean, if we can give authorization, we could post it just in the event thereof. Okay, so that can be worked out. Next question is, how much does it cost to go to participate in this program?
Was it $678? I don't remember. $639.
Can we afford to provide budget for 2 people?
You know what, now that I'm thinking about that, should we have waited for Denise to come in for this?
Denise will not be in the office until 10:30.
Oh, okay.
Then we can move in her absence.
The question, this question came up, I believe, during the general meeting, and the answer was yes, we did have, because no members have done any training, well, no, in years, but you have, but free trainings you've done, right? In a number of years. So as a result, we do have sufficient funds and more than sufficient funds.
Is it?
Sorry, Ms.
Go ahead, Ms.
Go ahead.
Burr.
I just wanted to, the senator mentioned, I don't know, I wasn't sure why, but he sounded like he was questioning Dr. Lerner paying it. It's a matter of him paying in advance and getting reimbursed, only because the class starts on Monday, and so there's not enough time for the district, even if we approved it today, to get a check ready and there before Monday. And that's why he would be reimbursed, as opposed to the district having it there in advance.
Oh, I see. So therefore, it would be appropriate, I would assume, to vote to adopt such a motion, a request, and in the eventuality that it opens up, then the doctor would be reimbursed. And not only we hold a degree as a medical doctor, but he also had one as an attorney.
Say that last part.
Not only would he have a degree as a medical doctor, but he had one as an attorney.
Well, as someone who went through 3 years of law school at NYU, I have to say, I don't think you'll be a lawyer, but you can play one on TV, I think. Shall we take that? Thank you. Shall we take that as a motion? Okay, except for the last part, correct? Yes. I'm going to second that motion. In the eventuality that, that their space opens up, I will second the motion to reimburse Dr. Lerner for any payment of fees. Any discussion? Ms. Byrd?
I just wanted to say that Dr. Lerner, since you have expressed interest in training, I will try to always inform you of things that are coming up so that you can register, and I may have mentioned this, that you can register for these classes and then drop, which I have done on occasion, just to be on the list so that it's not an issue when you try to get in.
Oh,
We're not paying before we go, so we can register. And for instance, I'm registered for a course now 6 months out, and because it's a possibility that that course might be full by the time it approaches. So I'm not requesting that the district provide payment for it until an appropriate amount of time, but I can at least register with the NJC, and then I'm there in the event that I can take the class. I'm already registered and technically on the roll, but not paid.
When they register and therefore we pay for it, they don't drop your course and they just.
You have, I believe, 30 days to drop and I'm not 100% sure, but there is a method of reimbursement, but I don't request payment that soon. I usually request payment maybe a few weeks ahead of time, and I'm already on the list. So when they receive the payment, they just put me in the class.
But no, you don't drop the course after you make the
I've
payment?
never dropped the course after I've made a payment, so I don't know
Does that happen
exactly.
from time to time?
It could happen, and there's some mechanism for reimbursement. I'm sure there's probably some fee, but
Proportional?
yeah. So if you see anything that they're offering and you think you might want it, go ahead and register. I guess that's what I'm saying. And then if it comes up, you just present it to the board for approval.
Dr. Lerner, if you get in, hopefully you will complete the course, won't you?
Yes.
I think it's great. Dr. Lerner has expressed nothing but real interest in this course since it was presented. Okay, so there has been a motion to approve, should contingent upon Dr. Lerner actually getting in. Oh, and so everyone knows, when we move this business to today's schedule, we did actually make sure that it was okay with the district and within district policy to reimburse, because that's not normally the way it's done, and the answer was yes, so that's already been taken care of. So there's been a motion and a second. Ms. Byrd, how do you vote?
Yes.
And Dr. Lerner, I assume you vote?
Yes.
Okay, so it passes 4-0, and thank you, Ms. Byrd, for offering to keep other members informed of courses that look good well in advance. I like the idea that if anyone likes a course, to hold a position for yourself, and please keep in mind that requests need to be made at least, I would say, 2 to 3 weeks in advance, so that if requests are approved and within our budget, that the district can pay in advance and go through its processes. Okay, any other business, board members? Seeing nothing, we are adjourned.